It's a Thursday morning. Sarah gets into work early like she always does, with a cup of coffee in her hand. And before she can sit down to answer her first email of the day, boom, federal agents swarm in and seize everything. All Sarah was just a manager, and she'd been going through a rough time as of lately. See, she'd been going through a divorce, and she had been emailing her attorney, her therapist, and her sister, and telling them things that she would just never really say at work. But because her company is under investigation, federal agents can go through her private emails and collect everything. It has to do with a federal law most people have never read. And if they're over 180 days old, they can access her private emails without a warrant. How is any of that legal? Because some of those emails are over 6 months old. And under a law passed in 1986, emails that are over 180 days old are treated differently. The government can access them with something called a subpoena. That's a lower bar than a search warrant. No judge deciding probable cause, no requirement to tell her. Just a request to her private email provider, and most of her private communications are gone. Sarah's story is a dramatization of real things that happen to real people, because everything in this law is real. This scenario has played out in actual federal investigations with the IRS, with the SEC, and even local police coordinating with federal agencies. A law written before the internet existed is still governing your Gmail, your iCloud, and your Outlook right now. If this is your first time hearing about this, it won't be your last. Make sure to subscribe so you don't miss out on what's coming. Now let's talk about how a law written in 1986 still has this kind of reach over your life today. See, the law that actually governs the privacy of your email was written in 1986, 3 years before the World Wide Web even existed, 4 years before most Americans had ever sent a single email. Congress was trying to modernize privacy law for a technology almost nobody was using yet. And the assumptions they made in that moment have followed us ever since. It's called the Electronic Communications Privacy Act, or the ECPA. And it was the first real step forward when it came to maintaining privacy online. Because before it, the main federal wiretapping law dated to 1968, and it barely addressed electronic communication at all. The ECPA said, emails in transit are like phone calls. You need a warrant to intercept them. That part was genuinely good law. But then Congress had to figure out what to do with emails that had already been delivered and were just sitting on a server. And here's where a single, reasonably sounding assumption quietly became one of the biggest privacy loopholes in the digital age. They ended up deciding that old stored emails, anything more than 180 days old, they were more like abandoned property than private communication. Nobody would keep email that long, they figured. Storage was expensive, and a 6-month-old email wasn't really private anymore at that time. Back then, that logic made sense when floppy disks cost $1 each and hard drives held a few megabytes. It makes absolutely no sense in a world where your Gmail goes back all the way to 2004, your iCloud has years of photos and documents, and cloud storage costs essentially nothing. The assumption aged out decades ago. The law never did. Most people assume privacy law is simple. Either the government needs a warrant or it doesn't. The ECPA is not simple. It has 3 separate titles, each governing a different kind of access, each requiring a different legal standard. And the gap between the strongest one and the weakest one is enormous. The first one is the Wiretap Act. It's the strongest. It covers communications in transit right now. A call happening this second, an email being sent at this moment. To intercept any of that in real time, the government needs the equivalent of a full warrant, probable cause, a judge, the works. This protection is real and it holds up. Title II, however, the Stored Communications Act, is where it gets a bit more complicated. See, this covers communication that has already arrived and are sitting on a server. Your inbox, your old messages, your cloud files. Under 180 days, a warrant is required. Over 180 days, the government can use a subpoena, and they don't always have to tell you it's happening. And that's the loophole that people like Sarah run into all the time. That's the loophole most people don't know exists. In Title III, it covers metadata, the who, when, and how often of your communications without the actual content. Under this title, the government gets records of what you call, who you emailed, how often, at what times, with a court order that requires a lower standard than probable cause, just that the information is relevant to an investigation. And here's what matters about that. Metadata alone can build a detailed portrait of your entire life without reading a single word you've written. See, Title II is the real exposure for most people, and there's a real federal case that shows exactly what that exposure looks like in practice. 27,740 emails seized without a warrant from a man who had no idea it was happening until it was too late. It follows the story of a man named Steve Warshak, and he ran a supplement company in Ohio. The company got under federal investigation for fraud, and in 2005, the government went to his internet service provider and told them to do something that, if it had been done to his home, would have required a warrant, a judge, and probable cause. They told them, the ISCP, to secretly archive every single email Warshak sent or received going forward. All of it, without telling him a word. Then they issued a subpoena under the Stored Communications Act and collected the emails. 27,740 emails, including conversations with his attorneys, family correspondence, all of it without ever asking a judge to review whether there was probable cause. When Warshak's case went to trial, he challenged the email seizure on Fourth Amendment grounds. And in 2010, the Sixth Circuit Court of Appeals agreed with him on the privacy question. The court said, what common sense would tell you, email is the modern equivalent of a phone call or a postal letter. Quote, it would defy common sense to give email lesser protection than physical mail in your mailbox. The government needed a warrant, first federal appeals court to ever say so explicitly. But the catch was, Warshak only applies in the Sixth Circuit, Ohio, Michigan, Kentucky, Tennessee. In the rest of the country, the legal footing is less certain. And when the ACLU obtained internal IRS documents years later, they found that before Warshak, the IRS had a standing policy of reading Americans' emails without warrant. When asked whether it had changed that policy outside the Sixth Circuit, the IRS declined to say. That IRS detail isn't a one-off. The same access framework applies to civil agencies across the board. Agencies that have nothing to do with criminal law. And you never know it was happening until you received a notice you might not even understand. Because here's something most people don't realize about the ECPA. It isn't just a criminal law tool. The SEC, the FTC, the IRS, even civil enforcement agencies investigating civil violations, not crimes, can use the same subpoena standard to access old emails and cloud stored documents. You don't have to be a criminal suspect. You just have to be relevant to an investigation. Here's how it actually plays out. A federal agency opens an investigation. They identify accounts that might hold relevant communications. They send a subpoena to Gmail, Outlook, or Yahoo, or whoever you use for your email. The provider has to comply, and the government can request that notice to you to be delayed, up to 90 days in civil cases, longer in criminal. And by the time you find out, the investigation is already underway and the evidence is already in their hands. And it extends beyond email. Documents in Google Drive, photos in iCloud, notes in Dropbox. Anything stored with a third party falls under the same Stored Communications Act framework. The principle goes back to a case we covered called Smith v. Maryland. When you hand your data to a third party, your privacy protections shrink. Your email provider, your cloud storage, your phone carrier, all of them sit between you and the law. So the law has a real structural problem, but it also has protections people don't know they have. Understanding both sides of this is what actually matters. So let's go through them. Because let's be honest about this, the ECPA wasn't a bad law. In 1986, it was a genuine privacy win, and some of what it established still holds. Real-time communications have strong warrant protection. Unauthorized interception of your calls or messages by private parties is a federal crime, and the ECPA gives you a private right of action, meaning if someone illegally intercepts your communications, you can sue them directly. Statutory damages start at $10,000 per violation. The private right of action is worth understanding. You don't have to wait for the government to prosecute someone who violates your communications privacy. You can file the lawsuit yourself. That's meaningful leverage, and most most people have no idea exist. Now, onto the problems though. The 180-day rule treats like a 6-month-old email as legally weaker than a letter in your desk drawer, and that drawer could hold letters from 1995. The law has no meaningful protection for location data, smart device activity, or metadata patterns that can map your entire social and professional life. And the Wiretap Act's strong protection only applies to communications in motion. The moment your message is delivered and stored, that protection drops. The gap between what the law protects and how people actually live hasn't been closed. Congress passed a fix through the House, 419-0, and it died in the Senate without a vote. The gap still exists. And knowing the gaps is useful, but knowing what to actually do about them is more useful. So let's talk about something you can do right now. Practical steps that work regardless of whether Congress ever fixes the law. First, and the most important thing is in this video, end-to-end encryption communication. When you use apps like Signal for messages or Proton Mail for email, your provider cannot hand over the contents of your communications even if they wanted to. They don't hold the decryption key. You do. A subpoena to Signal for your message content returns nothing readable. That's not a workaround. That's the system working as it should. Second, know where your sensitive data live. Legal correspondence, medical information, financial records stored in standard and cloud services like Google Drive or iCloud have the same third-party vulnerability as your email. For genuinely sensitive material, consider encrypted local storage or a privacy-focused cloud provider. The tool matters less than the habit of thinking about where your most private information actually is. And third, if you ever receive a notice that a government agency has accessed your email or cloud account, that notice is legally required in most circumstances. It means access has already happened. Consult an attorney. You may have legal options depending on how the access was obtained, what circuit you're in, and what agency was involved. Don't ignore it. A law written before the internet existed is still the primary federal statute governing your digital communications. It has gaps that courts, civil liberty groups, and Congress have all acknowledged for decades. And yet here we are, still waiting on a fix that passed the House unanimously and then quietly disappeared. This is what this channel is for. Not to scare you, but to make sure the rules you're living under are invisible to you. Because when you know them, you can do something about them. Use encryption, know where your data lives, know your rights when notice comes. If this opened your eyes, share it. One person who sends emails, which is everyone. If you haven't already, subscribe. New videos every 2 weeks. Same kind of law, same kind of impact. Drop a comment. Did you know about the 180-day rule before today?